Welcome to Torn, the only podcast committed to exposing the truth about the child welfare system and its devastating impact on families of color, told from the perspective of your hosts, Sonia Johnson and Classie Colinet, two defense attorneys who have over 15 years of experience working in the child welfare system. Welcome to another episode of Torn, Season 2. You're joined today by your hosts, myself, Classie Colinet, and my co-host, my comrade in the trenches, Sonia Johnson.
Hey, welcome back, everyone. Classie, we are here on another episode of Torn. Yay! Season 2. Yay! Let's get into it.
Yes. So happy to be here with you, my sister. And so, Sonia, you know that there are 5 different types of cases that the division can bring against families. Can you tell us a little bit about how cases begin in the child welfare system, particularly in the state of New Jersey?
Well, in the state of New Jersey, all cases start with a call to the New Jersey Child Abuse Hotline. And once the state gets the referral, it will attempt to investigate the allegations within the referral to determine whether they are accurate and or whether there has been an act of abuse or neglect. The state has approximately 45 days to conduct this investigation. Now, it should be noted that a child may be removed before the investigation is completed if the state believes that a child needs to be removed for safety reasons. And you and I have had cases where that has been the case, right, Classie?
We have. And I was going to say, Sonia, how is that fair? Because you just said they may not, that the Division of Child Protection and Permanency may not be done with their investigation, meaning that 45-day period. And again, I know you said usually within 45 days, sometimes it is more, but there is at least going to be a 45-day period wherein the investigation takes place. How is it fair that someone could lose their children and have their children placed in foster care before the investigation is over?
It's a good question, and I don't have an answer for you. I mean, I know that the overarching concern is the safety of the child. And so as far as the state is concerned, that they'd rather err on the side of caution than to leave a child in an unsafe space and then find out that they should have removed the child. So unfortunately, that's just how the system is set up. You know, the investigations, however, as we indicated earlier, you know, they've got about 45 days. And as you said, they can take longer. The investigation includes talking to parents, even, you know, parents that don't live with the children, relatives, and other people who have information about the allegation. And sometimes the person who made the call, depending on who it is. So you and I have had cases where a parent is asking who made the referral. And we know that that information is kept anonymous. And it's usually, the only time that information is usually disclosed is if it came through a hospital or sometimes even the school. And it's just because the parent is able to deduct who made the referral based upon the context of the referral. But during the investigation,
come out at trial too, right? Like if a parent has a trial.
Right, exactly. But as we know, referrals can come in anonymously. And so there is no one to interview and there's no one that the parent can necessarily challenge face to face sometimes. An investigation can also include requests for records from schools and physicians. And so, you know, the minute the division becomes involved with a family, you know, it's more than the family that knows about the investigation, even though we like to say that these proceedings are confidential, because the school can get a document from the division wanting to know what's going on with this child, you know, and ask a number of different questions about the child. So that is part of the investigation. The investigation can also include the state entering into a parent's home. And this is without any kind of warrant or any kind of process. The investigation can also include checking a child's body for abuse and talking with the child directly without the parent being present. Now that's a big one, right, Classie?
Yeah, absolutely. Sonia, can you break down a little bit about what you mean when you say checking a child's body for abuse?
Okay.
And then also talking directly with the child. That's my second inquiry.
Okay. So the state can ask to see a child's body for evidence of abuse. So if the call came in to the hotline alleging physical abuse of a child, the caseworker who is investigating that referral can ask to see, the child's body, lift up the shirt, pull down the pants, anything, any place where evidence of an injury or evidence of abuse may exist. The investigator has a right to look to see. The investigator also, to your second question, the investigator also can talk to the child about the abuse, the alleged abuse that is going on in the home. And the thinking is that you want the child to speak freely about whatever abuse might be going on in the home. So then the investigator will ask to speak to the child outside of the presence of the parent or alleged perpetrator. Usually it's both parents. And so that they can assess whether or not the child has something to say that the child would otherwise not say if the parent were present. So that happens. And we know that parents come in and they are just enraged that the state can completely exclude them from this process. But from the state's vantage point, they're really trying to protect children. And that's one way to kind of get at the truth, by being able to, make those inquiries and make those inquiries as quickly as they possibly can. We also know that sometimes the division may ask a parent to submit to testing as part of their investigation.
They love the tests.
Oh, absolutely. Absolutely. Now, it's a tricky thing, right, Classie? We know that it's a tricky thing whether or not you agree to doing testing at this point. Mm-hmm. And what's your thought in terms of whether or not parents should do testing?
Yeah, Sonia, I generally lean on my client for this one, because I generally will have a one-on-one discussion, straightforward discussion with my client, and just tell my client, listen, if you test positive, things could really take a turn for the worse. So if you are certain that you are absolutely going to test negative and there will be no traces of any illegal substance in the test, then you should go ahead and take it, because that may help fast track the case such that the case could even be possibly dismissed. I've had situations where the prosecutor, also known as the deputy attorney general, says to me, hey, Classie, if your client tests negative, we'll just close the case right now. We'll close the case immediately.
Right.
And then if that is the case, Sonia, where the prosecutor is saying that they would close the case immediately, I asked them to put that in the court order. That the division has represented that they would consent to a dismissal if so-and-so, right, and that would be the name of my client, tests negative when they take the test on such and such date. But then, of course, Sonia, there's other instances where my client doesn't know for sure whether or not they will absolutely test negative. And so we generally push back and we remind the court that at the depending on the type of action that it is, particularly at the order to investigate stage, there's not necessarily a requirement that a parent submit to a test. So if we are at the order to investigate stage, and I will get into that a little bit later, but if we are at, for example, that stage, my client's not for sure that they will test negative, then we abstain and we ask the judge to refrain from ordering my client to do any tests at that juncture.
But before we get into the orders to investigate, which is one of the ways in which families are regulated in the child welfare system. And you talked about, what you would advise your client, but that's after the case has been brought in. And in most states, state welfare workers these investigations are happening before the case is brought in, right? And so they're asking parents to submit to test as part of their investigation. And the problem, is that parents do not have any kind of understanding of what their rights are at this particular point in time. All they know is that a state worker has shown up and said, we have this referral. You need to cooperate if you want your kids to stay in your home.
Absolutely.
And so parents don't know what rights they have. And what most folks don't know is that there is no Miranda type right in our cases, right?
Correct. And Sonia, can you tell our listeners what you're referring to when you say Miranda?
So we've all seen the television programs or court type programs where when the police are in the middle of an investigation and they want to question you, that they run down a list of rights that you have. You have the right to remain silent. You have a right to an attorney. Those are Miranda rights. There is no equivalent in the child welfare system. So when the caseworker, who is the equivalent of the police officer in child welfare cases, show up and they're in the context of doing an investigation, they don't read any civil Miranda rights. And there's a question. Should caseworkers be required to read civil Miranda rights to parents they are investigating for child abuse? As you know, I think it was New York attempted to get a civil Miranda rights legislation passed. There was a lot of support for it, but unfortunately it did not pass. Interestingly enough, there was another state, and I think if memory serves me correctly, it was Texas. Texas did pass the civil Miranda rights statute.
Nice. Okay.
And so my question for you, Classie, is, should New Jersey have a civil Miranda rights statute, particularly for application in these type of cases? What do you think?
Absolutely, Sonia. Absolutely. And that is because what parents say or do, right? And when I say do, I mean any test that they submit to, whether that is a urine screen, whether that is a hair follicle, whether that is a psychological or psychiatric evaluation, any type of evaluation, the results of those tests usually are used against the parents.
They are.
Future proceedings. And so parents should know at the front end, if you agree to any of this, let alone even if you agree to talk to me without a lawyer present, anything you say or do can and will be used against you.
In a court of law.
In a court of law, absolutely. Yeah. And that should absolutely come at the front end, Sonia, because I will tell you, Sonia, in the course of my career, I had one trial, and I couldn't believe it, but I had one trial where the judge was so infuriated that the Division of Child Protection and Permanency had used all of the information regarding my client's mental health. My client was trying to be as forthcoming as she possibly could. She had given her worker all of her documentation, all of her medical records, and little did my client know, my client was doing it in an effort to hurry up and close the case and hopefully not end up with a case in court. Well, that turned out to be evidence used against my client at trial.
Right.
And in fact, the judge asked the caseworker on the stand, I'll never forget it. The judge asked the caseworker point blank, did you tell Ms. Colinet's client at the time in which she gave you all of this information that you would use it against her in a future proceeding. And the caseworker said no. The judge was infuriated. And Sonia, that's the same reason why we as defense attorneys are infuriated. Our clients often give information in an effort where, they're just trying to clear up things. They're not trying to make things worse.
Right.
They're not trying to end up with a case where they even have to make a decision about whether or not to go to trial. They're trying to avoid all of that. So they absolutely should be told at the front end and given the Miranda warning for the reasons that I just said, because I think it would really help parents get clarity at the front end.
At the very outset.
At the very outset. So there would be no gray area. It would not be, well, I'm not sure. We'll see. They should just know at the outset, this is going to be used against you.
And you know what, Classie, because that's also the child welfare system makes it seem as though they're just here to help, that they're your buddies coming alongside of you. They want to support you.
Absolutely.
But if you tell me what my rights are and you tell me that all of these tests are going to be used against me, I know at the outset that this is an adversarial process. I need to wake up and understand what I'm about to enter into or what it is that I'm trying to avoid, and really navigate that in a way with an understanding that it is an adversarial system that you are confronting. Classie, let me ask you this. What if a parent says, you're not coming in my house. You're not looking at my child. You're not talking to my child without my permission, without me being there. This is not happening. What happens then?
Well, first and foremost, I want to say, those are my kind of clients. I love those kind of clients. I love all my clients, but those clients in particular, we always have a good time in the course of the case, because those generally are parents who are standing up and saying at the outset, you will not come and interrupt and interfere with my family's life. Now, what happens when a client does that? It wreaks havoc. It wreaks absolute havoc, because the Division of Child Protection and Permanency, they often, and quite frankly, just child welfare agency workers in general, like you said, Sonia, they often want families to think like this is a partnership and we can work through this together. And Sonia, I will tell you, in an ideal world, that is the goal. That absolutely is the goal. And as a defense attorney, I always want that to be the goal. Unfortunately, that is not often the goal at the outset. Only because, like you said in the beginning of this episode, these cases generally start with a call from usually some type of anonymous caller, or maybe it's someone that has made themselves known to the parent. Hey, I called the child welfare agency on you. So the case is already starting out with some level of suspicion. The person called in because they have a suspicion that something is going wrong with these children or this child.
Right.
Or they actually observed it. And then they're calling after the fact and saying, I just saw this happen. So when a caseworker shows up after having received that information regarding suspicion and or from the caller's perspective, actual information that they say something actually took place, the caseworker is naturally going to be suspicious of our clients.
Absolutely.
And so the thought of a client saying, yeah, that's fine for you to talk to my son. Yeah, that's fine for you to come in and walk around my house. They're not okay with that, because they're like, well, I already know you're looking for something because you've received some negative information about me.
Right.
Now, granted, Sonia, I'm a defense attorney, but I'm also honest enough to say sometimes it is factual information.
Exactly.
Who's calling in, but sometimes it's not.
Right.
And so the caseworker doesn't know what scenario it is, and so they often start off naturally, as we would expect them to. They start off with like, well, I got to find out what went wrong and why. and how.
I got to find the abuse.
Right. I have to find it. I have to find it because I just received this anonymous call.
Right.
And I have to find it like immediately. That's what I'm hired to do by this agency. We have to find it. So, go ahead.
I was going to say, it could be a call about physical abuse, but they're still sending that request for information to the school, you know?
Right.
So, or it could be a referral for educational neglect, but they're still sending that request for information to the pediatrician. Right. So while I agree with you, you know, I like clients that are like, wait a minute, I'm not going to allow the state to roll over me. But we do know that, you know, the first type of case that the state can bring is what's called the order to investigate, which you mentioned earlier. And that's the state brings that case when, you know, parents take that position. So could you explain a little bit more about what the order to investigate is?
Sure. Yeah. So an order to investigate is usually brought by the state when the parent has interfered with the state's investigation.
Yeah.
That's exactly what we were talking about. Those clients that say, absolutely not, you're not going to talk to my son. You're not going to talk to my daughter. You're absolutely not going to get any information from the pediatrician. And when that happens, when a parent interferes with the state's efforts to investigate abuse or neglect, the Child Welfare Agency can apply to the court for an order directing the parent to cooperate. And so one example is what you said earlier, when a parent refuses to allow the child welfare worker to see a child's body. And I just want to highlight with regard to orders to investigate. At this stage, the Child Welfare Agency is not permitted to get an order for testing. And when I say testing, I mean urine screen, hair follicle, but there's a big but here. Sometimes my clients agree to the testing because they just want to get the case over and done with. Because let's say, for example, the anonymous caller called in and said, well, that the caller has a suspicion that the parent is abusing illegal substances. Well, in that instance, my client will say, you know what, Classie, let me just take the urine screen so they could see that my urine is clean, there's nothing in it. And that way we can hurry up and wrap up this case and I don't have to worry about ever showing up to court again. And in those instances, I say, great, go ahead and do it. Let's close up the case. Let's move on. And I will tell you, Sonia, many times that is what happens with respect to an order to investigate. But there's also other types of cases. There's the Dodd hearing. And that's, of course, when the state comes in, they come into court and they seek to get the court's endorsement of a removal that they've already completed of a child.
Say that again. They can remove children before getting a court order.
They can. Yes. It is it is, and I'm going to try to be as neutral as I can as a defense attorney. But again, Sonia, sometimes this information is factual that the anonymous caller has called in. And in instances, period, when the Child Welfare Agency feels as though they've done their interviews, they've done whatever due diligence that they believe was needed to determine what is happening with a particular child or children. And if they determine that they still think that the child would be exposed to harm, namely abuse and or neglect, then they will seek to remove that child, and it will be without a court order. Now, the legislation in New Jersey, there is a requirement under the statute that the Child Welfare Agency have a hearing with the court immediately. There is a requirement that the state must bring that case before the court for review of its actions within 3 days. So it has to happen within 3 days. But yes, absolutely.
That's 3 business days, though, right?
Right.
Yeah, right.
Thank you for that, Sonia. Right. Because if my client's kid was taken on Friday, they may not get to court till Tuesday.
Right.
Now, I will say many times we are in court on Monday, but sometimes we don't make it till Tuesday.
Right, right.
And Sonia, can you talk a little bit about how that impacts parents? 3 business days doesn't sound like a lot to you and I, but what does that feel like for a parent who has had their kid taken?
I mean, it's excruciating. And as a parent attorney watching and representing parents who are just distraught because their child has been removed by a state agency. And, I've heard clients talk about the child crying, screaming, being ripped from their arms. It's heartbreaking. It's absolutely heartbreaking. It's heartbreaking for me as a parent attorney listening to my client's account of it. I can't imagine what it's like for a parent actually experiencing that. It's just really, really sad.
Absolutely.
Classie, what can you explain to our listeners what types of cases usually involve DODS?
Right. Yeah.
And DODS is, just before you answer that, DODS is the name of the senator who introduced this legislation. I can't remember what his first name is, but that's what we just refer to these removal proceedings as DOD proceedings. So, Classie, what kinds of cases are normally DODs?
DODs are normally cases where the Child Protection Agency believes that a kid has sustained a serious injury. In my experience, I have seen cases where a child has been burned, cases where a child has been spanked to an excessive point, to a point of excessiveness. And also one of the other cases in which there was a DOD, it involved a set of twins who were infants and were found unattended in an apartment for an inordinate amount of time. So that's just like a quick highlight of the types of cases that usually involve a DOD.
I've also seen cases where there is a severe substance abuse problem with the parent, where the parent is dozing, falling asleep, and leaving the child either in a public place or has been found with the child, with, unfortunately, a needle in the arm. I've seen those cases. And the other types of cases are cases where there's severe mental illness, where there's a concern that the parent might harm the child. And another type of case is what we call unexplained fractures. And that's when a child shows up to the doctor's office, or it could be in the emergency room. And in my experience, it's typically been infants with unexplained fractures, a leg fracture, or arm fracture, or a skull fracture. And typically in those cases, at least the ones that I've had, the parent is just as shocked to find out about the fracture as everyone else. But because the parent can't explain the origin of the fracture, then the parent or parents become suspects until proven otherwise. And so those cases are cases that are dotted in my experience. Classie, there's a third type of case that the state brings, and those are child abuse and neglect under Title IX. Can you explain what those are?
Sure. So Title IX is a statute that we have in New Jersey. And these types of cases are when the division believes that an act of abuse or neglect has occurred against the child. And then because the division has determined that, the way in which they determine that is through an investigation. And so what we talked about at the top of our episode is that the Child Welfare Agency does an investigation. And so these are cases in which they've done their investigation. And then after their investigation, they have issued a finding. And so there's various types of findings that the Child Welfare Agency can make in New Jersey. The most serious type of finding is substantiated. And substantiated means that the child welfare agency believes that there was abuse and or neglect. Now, if a parent has been issued and notified that they were substantiated by the Division of Child Protection and Permanency, they do have an option to go to trial. And so at trial, the judge will determine whether or not the child welfare agency made the right decision, whether or not this really is based on the evidence that was presented at trial. The judge will have an opportunity to either say, the child welfare agency got it correct, the findings should remain substantiated. Sometimes the judge says, you know what, I actually think that the child welfare agency got this wrong. I'm going to determine that it's unfounded, meaning that there is no abuse or neglect. And then there are also other types of findings that...
Before you go into the other types of findings, can you talk about the significance of a substantiation? If the court does not overturn the child welfare agency's finding and find that they were wrong and the substantiation sticks, are there any repercussions outside of the litigation, outside of the case, to that upholding of that finding?
Absolutely. Glad you asked. Yes, when a parent is substantiated and a judge determines that that substantiation should remain, that parent's name is entered on the child abuse registry. Now, what is the child abuse registry? The child abuse registry is a registry that is state-based and is only accessible to agencies within the state of New Jersey, but it is a list that includes every person that has ever been determined to have committed abuse or neglect. And that registry is a terrible thing in that if someone's name is on that registry, that can impact that person's ability to get a job in certain fields, particularly if that person wants to be a daycare worker, if that person ever wants to work for the child welfare agency itself. Also, if that person ever wants to serve as a guardian for a relative's child. Those are just some of the ways in which the child abuse registry can impact an individual's ability to make a living. And the saddest part associated with the registry, at least in New Jersey, is that your name remains there forever. There is no way to get your name off of that registry. Now, Sonia, I know there's other states that have passed some progressive legislation whereby they give parents and families an opportunity to get their names off of the child abuse registry if after a certain amount of time a person can demonstrate that they have been doing good work, or I'm not sure what some of the requirements are, but they do allow a parent to get their name off of that registry after a certain period of time, or at least make a request to have their name removed from that registry. But in New Jersey, your name remains there forever. And that would be detrimental.
I think it should be something that we should really look into as far as New Jersey is concerned, because, I mean, you mentioned some of the negative impact in terms of employment, but the impact goes farther than employment, because if you are on the child abuse registry, you cannot coach Little League. You can't, participate in anything where there's a request for you to have what's called a carry check, a child abuse registry inquiry. Mm-hmm. If you pop positive or if you're on that list, you cannot participate. And so I know that I have had cases where grandparents have come forward and they have substantiations that are decades old. Mm-hmm. And notwithstanding the fact that they have lived exemplary lives and have never, done anything subsequent to that initial substantiation, they cannot come forward to be resource parents or supervisors because of that substantiation. Now, I know that in New Jersey, they're working a little bit with, kind of try to soften the supervisory portion of that. But at present, that could still be an impediment for people who have a substantiation. So it is significant if that substantiation is upheld. What other kinds of findings can the division make?
Sure. So beyond substantiated, the division can also make a finding of established, which means that they found some evidence of abuse and neglect, but there are mitigating factors, and the mitigating factors outweigh the other factors. And so with an established finding, that finding will only stay within the division's internal file. Then there's also a not established finding, which means there's no evidence that there was abuse and neglect, but there was evidence that a child was exposed to a risk of harm. That's the caveat with not established. And then with unfounded, it's exactly what it sounds like. There's been no finding of abuse or neglect, and so it is determined to be unfounded.
Other than the determination of whether or not a parent has committed an act of abuse or neglect, what other goal does the Title IX serve?
So Title IX is really designed to give parents an opportunity to defend against the state's claim of abuse and or neglect. And again, that's to help folks who want to clear that record. Like I told you, if you've been substantiated, your name is on that child abuse registry. So many times parents want to go to trial because they want a judge to determine if their name should remain on that registry, or in some cases, if it should be taken off. The second goal for litigation is also to allow the family to have an opportunity to access services to help eliminate the harm and or the safety concerns. So services are a real key part of the cases in the child welfare system and in these child welfare cases, because many times a case won't close until a parent has actually completed services or has engaged in a significant amount of services.
Classie, what happens if a parent is ordered to engage in certain services but just doesn't do it?
Well, Sonia, you and I both know that in those cases where we are the attorneys, we often have what we call that heart to heart.
Coming to Jesus.
Right. Coming to Jesus, straight no chaser talk. Right. We have that talk where we explain to a parent, listen, you have 12, give or take, sometimes 15 months.
And that's ASFA, right? That's
right, exactly.
Okay.
Right. That's the Adoption and Safe Families Act. And those of you who have not heard of that, please listen to our episode where we focus on that. We have a whole episode where we talked in depth about the Adoption and Safe Families Act. Very quickly, the Adoption and Safe Families Act, when that does apply to a case, that means that a case could eventually turn into a termination of parental rights case. And that is equivalent to the death penalty in child welfare cases. So I always try to help my clients avoid termination of parental rights cases, but sometimes it's inevitable. Sometimes my clients are just so exhausted and so downtrodden by the system and really even by their own circumstances that they do end up in a termination of parental rights cases. I do also just want to highlight, Sonia, what the burden of proof is at these trials. Again, our listeners may not really be that interested in the burden of proof. I think that's more lawyer talk, but I'll just highlight what it is. It means there has to be preponderance of the evidence, which means there has to be 51%, like a little bit over 50. Is that the easiest way to describe preponderance of the evidence, Sonia?
I think it is. And I think when, the way I try and explain it to clients is everybody has heard beyond a reasonable doubt because that's the standard that's used in criminal trials. And so the standard in a Title IX abuse and neglect case is way below that. It's preponderance. That means, I kind of think you did it. That's how I break it down. And it really does become, 50, 51. I kind of think you did it. That's the preponderance of the evidence standard. And that's the standard in child abuse cases. So I think parents need to understand that because, they're like, oh, this didn't happen. Da, 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 da. Well, we've had cases, particularly we mentioned the unexplained fracture cases where the parent, and, I typically believe my parents, they have no idea how the child sustained a broken tibia, leg fracture. But, the state introduces all this evidence and medical records and, medical professor medical expert that says, oh, this only happened through abuse. The judge is like, I think you did it. That's preponderance of the evidence. So the other type of case that we see, fourth type of case that we see is what's called family in need of services, FINS. And that's under Title 34C-12. We generally refer to it as family in need of services. And the thing that strikes me about this is the state can get involved when there is no evidence or of abuse and neglect. However, they believe that services are needed to protect the health, welfare, and safety of a child. And that's a lot of our cases, isn't it, Classie?
That is. Yep. Absolutely. That is. Yes.
And so it's typically the case where a parent does have a substance abuse issue, but there has not been an act of abuse or neglect. And so the state is trying to protect the child from the potential of neglect or abuse. Okay. And so the state will come in and request that the court take jurisdiction over the family and the child and order the parent to engage in services. The state does have to demonstrate to the court that the family is a family in need of services. But you and I both know that those hearings are they're not difficult. It's not difficult for the state to come in and to make that demonstration.
Not at all. Not at all. But Sonia, I do want our listeners to hear what type of services you have seen parents ordered to engage in these types of cases. Can you talk a little bit about that?
So services could be substance abuse counseling. It could be, if it's a case that alleges domestic violence between parents, it could be domestic violence counseling for the purported victim, batterous counseling for the purported perpetrator. It could be mental health counseling. It could be parenting classes. If there's an issue where it wasn't quite abuse, but it's evident that maybe a parent needs some understanding about child development and what's appropriate and what's not appropriate. Those are the types of services that come to mind. Now, even though these cases don't involve abuse and are limited in terms of when the court grants an application for a family in need of services, those applications, the court only has jurisdiction for 6 months. And every 6 months, the state has to come in and demonstrate why they continue to need to be involved. And again, you and I know that that's not a heavy lift for the state. And what is surprising is there is no limit to the number of extensions that the state can ask for.
Say it one more time, Sonia. And this time, can you tell us how long a case regarding family in need of services is supposed to last?
I'll repeat. The initial application is one for 6 months. the state can come in and ask for an extension before the expiration of the first 6 months and continue to make application after application after application. There is no limit to the number of times that the state can come in and make that application. In theory, the state has to demonstrate the ongoing need. But in cases that I've had, let's say it's a parent with a substance abuse problem and they're not, it's month 12 and the problem has not been resolved, the state can still come in and ask for an extension. And I've had cases that started out as family in need of services end up in what we've already sort of talked about, the fifth type of case that the state can bring, termination of parental rights cases.
Right.
So you can have a case where a parent did not commit an act of abuse or neglect end up being a termination of parental rights case. And when I first started doing this work, I just thought, wow, that is shocking.
It is. And Sonia, I'm just going to jump in and tell our listeners, what is a termination of parental rights case? Like, what's the actual definition, the title? So that's when the state has determined that a parent is unfit to actually be a parent. And they seek to terminate all of your rights to your child and end your relationship with your child forever. And it is final. It is detrimental. And Sonia, I know you and I, we both always do our best to make sure that parents don't end up in a situation where they're even having to fight in a termination of parental rights trial. But even if the court does determine that it is appropriate to terminate their rights, we always appeal. We always file an appeal. And I haven't won any appeals yet, but some people do win their termination of parental rights appeals. And it's always worth trying to restore your parental rights if you can. Again, Sonia, and I want to uplift this for our listeners. There are states that will allow parents who have gone through a termination of parental rights trial and their parental rights have been terminated. There are states that allow parents to restore their parental rights after a period of time.
Yes.
And Sonia, you and I, we need to do an episode on that. But unfortunately, New Jersey is not one of those states yet.
Yet. You
and I can take up one of the many causes that we're going to take up. But that is certainly something that the Garden State needs to think about, as well as other states, because there's, in my recollection, I think there may only be like 2 or 3 states that allow parental rights to be restored. But I do just want to highlight the burden of proof for termination of parental rights cases, and that is clear and convincing evidence, which means it's not beyond a reasonable doubt, which is, of course, what everyone sees in criminal cases, but it's also higher than the preponderance of the evidence standard that you just talked about.
Right.
So those are the types of cases that parents and families are going to encounter. I know, Sonia, we generally will jump into tips. And one of the tips that I have for our listeners is to always make sure that your lawyer explains what type of case you are in, because many times a parent will just show up, they'll come into court, they'll hear a lot of information, they'll get a court order at the end of the hearing, but they don't really know what type of case they're in. Is it an order to investigate? Is it family in need of services? Is it an abuse and neglect case? Is it a termination of parental rights case? So always ask your lawyer what type of case it is. And then another tip is to make sure you are actively engaged in the case.
Right.
Not just show up, right, Sonia?
Right.
I was going to say, can you tell our listeners, like, what do we mean when we say active engagement in the case?
Well, active engagement, that is, what type of case you're facing. You're actively talking to your attorney. You're communicating what your understanding is in terms of what you need to do, your time frame for getting them done. You understand the time frame that you are working against, and you are showing up. And, I say this, we as parent attorneys, I think we are some of the best people. We are understanding and we're empathetic. And I tell my clients all the time, it's a judgment-free zone. If you can't do it, I understand. Let's figure out the best solution that supports what you'd like to see happen for your child and for you. But if you want to do it, if you want to be reunified, okay, let's roll up our sleeves and let's get it done. And so I'm always encouraged by people who are struggling with mental health and substance abuse. And I've seen some really difficult struggles. And those people who are able to find it within themselves to dig deep and to really fight their demons, I'm right there with you. I'm right there with you. I'm so encouraged by, my clients who, they fall down, they brush themselves off, and they get right back up and they keep going. And as long as you give us as parent attorneys something to work with, we will work with you. We will argue and make the best arguments to support the outcome that you want. Classie, any other closing remarks?
I think you said it perfectly. Thank you, listeners, for listening. We hope you enjoyed this episode, and we hope you will tune in again soon. Have a great day.
Take care.
The opinions and views expressed on this podcast are those of its hosts and guests and represent our own lived experience. The views and opinions expressed do not reflect those of any agency or organization with which we may be associated.